For most of my career, I was a relentless multitasker. When I was a prosecutor, I'd have a victim on one phone line, a witness on hold, and a secretary in the doorway with her own phone, holding someone on her line that I could not afford to let hang up. All of this at once. I thought I was a high performer, and in many ways I was. But in many ways, I was just busy. And busy is not the same as being productive. The authors Mark Pallis and Sean McNalis of the book Time Management for Attorneys, A Lawyer's Guide to Decreasing Stress, Eliminating Interruptions, and Getting Home on Time, published by Atticus, they contend in Chapter 5 that batched focus work happens 4 times faster than multitasking. 4 times. In the next 20 minutes, I'm going to walk you through what I learned that finally got me to transition from being busy to being productive. I'm Robert Bunn. This is Estate Planning for Lawyers. Quick housekeeping before we dig in. Nothing in this podcast is legal advice, and no attorney-client relationship is created by listening or watching. There's a full disclaimer at the end. If you're listening on Spotify, Apple Podcasts, Amazon Music, iHeartRadio, or another audio platform, thank you so much. Very glad you're here. If you have a moment, I would encourage you to subscribe on YouTube as well, because the video adds another layer to the conversation. Any of this is useful. Please share it with another attorney who might benefit. Word of mouth is how channels like this find the people who actually need them. Now let us dive in. In the prior episode, episode 6, we worked on who you serve. We graded our current clients. We built a screening framework for the clients we were considering taking on. We talked about what it takes to clean up a caseload that has gotten away from you. Today we shift the question. Now we're talking about when you serve your clients, and more specifically, how you organize the week so that the right clients get your best work, and so that you actually get home on time. That last phrase is in the title of the Powers and McNalis book on time management for attorneys. Getting home on time. The authors are not writing about squeezing more billable hours out of your day. They're writing about building a structure that lets you do excellent legal work and have a life as well. In my view, that framing is what separates this book from most of the productivity advice that most attorneys hear. The goal is not more output. The goal is excellent output, delivered inside the hours you are actually supposed to be working. Powers and McNalis, writing about how attorneys should structure their week, open with a premise drawn from time and motion studies. When you perform similar tasks in the same block of time, you become dramatically more efficient than when you bounce between unrelated work. The authors apply this to law practice and say that batching light tasks can produce results 4 times faster than constantly switching between unrelated work. Again, because it is so critical, 4 times faster. The research, the authors suggest, conveys that every time you switch between answering a brief, taking a phone call, looking at a will, communicating with your assistant, you're losing time. And the lost time compounds throughout the day. The authors call the alternative the block and task method. You block things together, and then you tackle them. The example they gave is a reactive time manager who reaches for their reactive phone no matter what they are doing. The phone wins every time. And the file that you are working on loses every time. Powers and McNalis do not soften the consequences. They tie chaotic work patterns directly to liability risk. The authors note that many of the grievances filed against attorneys involve missed deadlines and disorganization. That's not a productivity argument. That is a malpractice argument. As an attorney, you need to hear that clearly. The way you organize your week is a risk management decision as well. The core tools that Powers and McNalis offer is called the time template. The time template is not a calendar. The authors are very specific about it. Your calendar still moves. Your calendar tracks specific appointments, hearings, and deadlines. The time template sits above one level above the calendar. It's the standing weekly structure that says, as an example, on Tuesday morning, I do this kind of work. On Thursday afternoon, I do that kind of work. The template stays the same week after week to the extent possible. The calendar moves underneath it. Powers of McNalis identify 9 categories of work that the authors say cover most of an attorney's week. I'll list them so the architecture is in your head, and then we'll walk through the most important blocks together. The 9 categories Powers of McNalis describe are planning time, production time, court time, meetings with staff, meetings with clients, returning phone calls, administration, client development, and time to systemize your practice. That is the architecture. 9 categories, 1 template. And the discipline to keep returning to it week after week until the structure becomes second nature. I am now going to discuss the most important block on the entire template. The one piece that, if you implement it, and nothing else from this episode, will change how your week feels within just a few days. It is what Powers of McNalis call the 3-part power hour. The authors break it into 3 sequential blocks that happen at the same time every day. First, you meet with your staff. The point of this meeting is to answer their batched questions and to delegate. The authors call this batching. And the idea is that the staff hold their question instead of just interrupt you all morning or at different times, willy-nilly, when they need it or most convenient for them. They walk in with a list. They walk out with a delegated plan. Second, you go behind closed doors. This is the power hour itself, or power hours if more than one. Powers of McNalis describe this as 1 to 3 hours of focused production, working only on the tasks that cannot be delegated. The authors identify several types of work that fit here. The heavy drafting that demands your full concentration, the substantive research that cannot be handed off, the analytical work on files that require your judgment, the preparation that has to happen before trials or hearings or significant client meetings, and the supervisory review of work that others have done for you. In short, the work that only you can do. Third, after production, you return phone calls. Powers of McNalis, they recommend that your assistant or call screener schedule callbacks at 15-minute callbacks back times during this block. The authors are very clear. Callers should never simply be told to call the attorney back. That feels uncaring to the caller, and it makes the attorney look inaccessible. Instead, the team schedules a specific time. The caller gets a definite expectation, and you keep the appointment. Powers of McNalis even provides language your staff can use when handling these calls. The phrasing the authors recommend is warm and confident. The tone is one that signals to the caller that they matter and that you will be reaching back out at a specific time. The point of the approach is that the client never ever feels brushed off. This system protects your time without damaging the relationship. The quoted examples from the book are excellent. If you implement only one thing from what we're discussing today, implement the power hour. The discipline of a closed door for 1 to 3 hours a day is the difference between an attorney who's productive and an attorney who is just busy. Inside the planning block, the authors introduce a triage framework I think most attorneys can benefit from. Powers of McNalis make a point that lands very hard for me. The authors write that having too many priorities is the same as having no priorities. That is so absolutely critical, and it's so resonating with me. In case it's helpful to you to the same extent, I want to emphasize it again. Having too many priorities is the same as having no priorities. When everything on your list feels important, you end up grabbing whatever feels urgent. And the authors warn that urgency is often mistaken for importance. The squeaky wheel client gets your morning. The quiet, profitable client waits. By the end of the week, you spent your time serving the loudest people instead of the right people. So the authors recommend you triage your to-do list. The term triage refers to the process of sorting and prioritizing people, tasks, or problems according to the urgency of their needs and the likelihood of benefit from intervention. In its original and still most common medical context, it is the practice of assigning degrees of urgency to wounded or ill patients to decide the order of treatment when resources are limited. The term has since expanded to general usage, applied to any situation where competing demands must be ranked and addressed in order of priority, such as triaging emails, client matters, or repairs. This kind of prioritization thinking is not unique to Powers and McNalis. Stephen Covey writes about it extensively in The 7 Habits of Highly Effective People. And President Eisenhower famously used a related framework to sort his daily decisions during the most consequential years of the 20th century. Powers and McNalis simply give us a practical, attorney-specific way to apply it. For our purposes, we will use a simple A, B, and C ranking. A tasks are the highest priority. Powers and McNalis identify 4 questions to spot one. Does the task advance a long-term goal? Is there a pending legal deadline? Is there a client expectation attached to it? Is there a cash flow consideration that would drive what you do next? If the answer to any of those is yes, the authors call it an A. It's an A priority. B priorities in the author's framework are tasks that do not require unique skill set and can be delegated. C priorities that should be delegated or delayed as long as possible. Then within the A category, you label them 1, 2, or 3, based upon which is most important, or more if you have more. The authors are blunt about the cost of getting this wrong. Powers and McNalis, they warn that the high maintenance of impossible to satisfy clients will drag your week into urgency without producing meaningful long-term value. If your practice is built around squeaky wheels, your important work goes undone and your profit margin suffers. The next block I want to highlight is what Powers and McNalis call the case status review meeting. This is a systematic scheduled review of every active matter on your inventory. The authors describe 2 cadences depending on your tolerance and your caseload. Some attorneys do 1/4 of their caseload every week. Others split the caseload in half and review it twice a month. Either way, the discipline is the same. The authors group files into 3 categories: files that are open and actively moving, files that are open but in a holding pattern, and files that are essentially complete but have not yet been formally closed. Each file gets a substantive update or a financial check or both. The authors also recommend folding a financial review into the same meeting. Bring in the accounts receivable report, or better, invite the bookkeeper. The authors note that attorneys often work for clients who never pay them, and they argue this is preventable. Powers and McNalis call their approach the zero tolerance collection system. The 3 elements the authors identify are proper client selection, always receiving a retainer, and including a replenishment clause in the fee agreement. The author's point is that case status meetings are not optional housekeeping. They are how you supervise a larger caseload responsibly, how you protect against grievances, and how you make sure you're getting paid for the work you are doing. The final block that I want to highlight is client development. Powers and McNalis are direct about this. The authors write that most attorneys complain they do not have time to market, and the authors respond that you have to make the time. Otherwise, the work does not get done. The authors recommend roughly 3 substantial marketing contacts per week. If those contacts are lunches, the math the authors calculates around 150 marketing lunches a year. The author's point is that client development is a numbers game built on repetition. People refer people to clients and to attorneys they like and trust, and that takes multiple touches. Powers and McNalis recommend you put these blocks on the time template itself. Visible, recurring, defended time. If the slot is not there, you will not fill it. And if you do not fill it, your pipeline goes quiet and dry, right around the time you finally have the bandwidth to take on new work. I want to talk about this as a Florida attorney who's building an estate planning practice, and as someone whose professional history sits in 2 very different camps. Before I founded Bunn Law, PLLC, I was an assistant state attorney. Then I was general counsel at a private equity firm for over 15 years. Those 2 roles taught me opposite lessons about time. As a prosecutor, my time was structured for me. The court told me when to show up. The docket told me which case was next. The clerk's office, statutes, and court rules dictated when filings were due. I was reactive by job description. And the system around me imposed a structure that I needed. As general counsel, my time was the opposite. I had to invent the structure. There was no docket. There was no clerk. My firm operated across numerous portfolio companies, and my work moved across all of them. I had enormous autonomy, and it was a job I really enjoyed. The priority poll often changed multiple times in a single day. It was never boring, and I was always learning new things and stretching and expanding my knowledge and capabilities. But the bandwidth question was always real. The lesson I learned over those 15 years is that if you do not build your own structure, the work will build it for you, and it will not be the structure you would have chosen. As Powers and McNalis make clear throughout their work on this topic, it will not be the most productive one either. I know now that a structured block and tackle approach would have been incredibly helpful, and I'm trying to benefit and get used to this structure moving forward. The structure problem is bigger than it has ever been because there's no court forcing me into a courtroom and no executive team forcing me into a board meeting. There's just me, my staff, my clients, and my calendar. The estate planning client load is also kind of unique. The work tends to be more predictable than litigation, which means the time template approach is, in my honest assessment, possibly more useful for an estate planning practice than others. Our work batches well. Reading the material, the section that landed hardest for me was a prioritization section. Powers and McNalis writing that having too many priorities is the same as having no priorities is a statement I'm considering putting on my office wall. Most of the chaos I lived through in my career came from treating every request like an A. The truth is, most requests are B or C. The discipline of triage is something I'm actively working on, and I do not have it solved. The other piece I'm applying right now is a 3-part power hour. I'm protecting a production block in the morning. Door closed, phone routed to my assistant, email closed. The first few times I tried it, felt uncomfortable, like I was being unavailable. Powers and McNalis warn about that feeling specifically, and they were right. 3 weeks in, I will not give it up. Here's the part of the conversation where I want to turn theory into something you can actually act on. 5 things you can do this week to put this material to work. Each one is small enough to start the very next time you sit at your desk, and large enough to change how your week feels within just a few days. 1. Draft your time template. Use the blank template that Powers and McNalis provide in their book, or sketch your own on a piece of paper. Get the 9 categories blocked across a typical week. Don't aim for perfect. Aim for a draft you can implement for the next 2 weeks. 2. Protect a daily production block. 1 to 3 hours every day. Door closed. Phone calls scheduled for after, not during. If you do nothing else from what we do today, do that. 3. Triage your to-do list before you schedule it. Label every item A, B, or C using the author's 4 questions. Then label the A items 1, 2, 3, 4, etc. Schedule from that list. Delegate the B list. Delete or defer the C list. 4. Have the conversation with your staff. Powers and McNalis, they provide language for it in the book. You cannot run a time template alone if you have people you're working with. The people you're working with have to understand what you're doing and why, or they'll have to accidentally undermine it. Block 3 clients a week. Lunches, calls, F1 viewing party, whatever fits your market and your personality. Put them on the calendar. Defend them like they are court appearances, because in a real sense, they are. Do these 5 things and your week will look different by the time you get to Friday. Our personal takeaway from this material is this. I would call the time template the architectural framework that Powers and McNalis focus on in their book, Time Management for Attorneys. Once that is in place, the rest of their advice starts to make a different kind of sense. Without it, every other piece of advice is something you're trying to fit into a week that kind of has no shape. With it, every other piece of advice from this and each one of the prior episodes has a specific place to live. The book is about, among other things, getting home on time. That phrase is in the title for a reason. The chapter is not about output. It is about building a structure that lets you do excellent legal work and be the kind of person who has dinner with their family. As someone who has worked too many weekends and too many roles, I find that framing genuinely persuasive and retroactively haunting. In the next episode, Powers and McNalis turn from the architecture of your week to the architecture of your actual files. We will talk about how to build a repeatable checklist for the work that comes to your door, how to create standardized templates for each type of matter you handle, and how to organize the paper on your desk so that nothing falls through the cracks. If today's conversation was about how you spend your week, the next one is about how you spend your attention while you're doing the work. The two work together. You'll want both. Before we close, thank you for spending your time with me today. I know your time is valuable. The fact that you spent some of it here matters to me. My hope is that the last 20 minutes was useful to you, something you can put to work the very next time you sit down to do your most important work. To reiterate what was said at the beginning, nothing in this show is legal advice, and no attorney-client relationship is formed by listening or watching. The information presented here is general and educational, and is not a substitute for advice from a licensed attorney in your jurisdiction reviewing your specific facts. The views I share are my own on behalf of Bunn Law PLLC. All references to time management with attorneys, a lawyer's guide to decreasing stress, eliminating interruptions, and getting home on time by Mark Powers and Sean McNalis, published by Atticus, are made for commentary and educational purposes. All rights in that work belong to their respective owners. My discussion is commentary and analysis, and neither the authors nor the publisher have endorsed or affiliated with this show. I recommend everyone buy a copy. Subscribe to Estate Planning for Lawyers so you will not miss our next show. I'll see you there.